Okay, I believe we're ready. We'll go on the record. This is KCR 22-21-16-23, State versus Chad Daybell. Representing Mr. Daybell is Attorney John Pryor. Representing the state are prosecutors Rachel Smith, Rob Wood, and Lindsay Blake, and Tanya Rawlings as well. I've got staff attorney listening in on this as well. And a court reporter is reporting the proceedings. We're also live streaming this hearing on the court's YouTube channel to provide public access to this. The court received a request, I believe it was yesterday or the day before, from the state asking if we could schedule a status conference. I would note we've got additional hearings scheduled for tomorrow morning in the case. We've agreed then on shortened notice to hold this status conference, fitting it into the court's calendar today. Mr. Wood, what's the nature of the need for this status conference this morning?
Well, Your Honor, yesterday, I think, and I'll let Ms. Blake correct me if I'm wrong, we initially were told we would just set the state's motions to continue for Friday morning. And we had asked for either a status conference or a hearing on those. And then soon thereafter, we got the email from the court saying we could have the status conference. The state's purpose for asking for a status conference was just for scheduling. And if we still need to have our hearings on our motions to continue, that's fine. But we did have some concerns, and I'll let Ms. Smith address our concerns for the hearing tomorrow on the state's motion to reconsider in terms of new evidence or possible new evidence. We want to make sure we're giving the court accurate information and Mr. Pryor accurate information. And then we also had, we filed a motion to continue on Mr. Pryor's motion to dismiss. I would note we were initially informed that all 5 of Mr. Pryor's motions were set for next week. But I believe, and again, if I'm wrong, someone feel free to correct me, that it is only the motion to dismiss. However, 2 of his other motions also include a request for dismissal. So we need one clarification, and we would still be wanting to have a motion to continue that for the state to have adequate time to prepare.
Okay, so to clarify what's currently on the calendar, tomorrow morning scheduled is the defendant's motion to sever and the state's motion for reconsideration. Next week on the 23rd is the hearing on the motion to dismiss filed by the defendant. But I understood with the other motions Mr. Pryor filed, and those were filed under seal, that those were not yet scheduled for hearing. So in the court's mind, we've got the 3 pending hearings, 2 for tomorrow and the hearing next week on the defense motion to dismiss. In terms of this morning, then, we did indicate this was a status conference. Is it then the state's intention you want to argue the merits of the motion to continue your motion to reconsider? And I'll note the court already issued an order on the motion to sever, denying the motion to continue that. So we will go forward on the motion to sever, but on the state's own motion to reconsider tomorrow, that has not yet been determined. And on the short time frame here, I'm just curious as to whether you are indicating you want to hear the motion to continue at this time, and if so, I'll need to inquire as to Mr. Pryor as to whether he's prepared to do that. So Mr. Wood or Ms. Smith, do you want to clarify that issue?
Yes, Judge, I think it would be the state's request that we be allowed to argue that this morning, or at least provide the rationale to both Mr. Pryor and the court. We filed that motion, I believe, late last Friday. I'm not sure where it sort of went through in technology, but so yes, that would be our request this morning.
All right, Mr. Pryor, so on that limited issue of whether or not we should continue the state's motion to reconsider, do you want to, and are you prepared to hear argument on that this morning and respond to that? Or would you request that we take that up at a later time, knowing that we don't have much time between now and when that's set?
Judge, I did receive the notification. It was close to 5 o'clock on Friday. However, I think I'm prepared to argue the motion to continue the motion to reconsider. I think that's appropriate to argue that today.
Okay.
I'm fine with that, Your Honor. Thank you.
All right, Ms. Smith, then if you'd like to make argument as it relates to the state's motion to continue your motion to reconsider, you can do so at this time.
Wonderful. Thank you, Judge. The state is requesting that there be a short postponement of the hearing on our motion to reconsider, essentially for two reasons. One, the state wants to supply the court the most accurate information it can. And two, we want to be able to get the information to Mr. Pryor in time for him to evaluate and address it as part of sort of our due diligence in sort of a discovery process. Last week, in anticipation of our hearing, we sat down to meet with our witnesses and doing our due diligence, double checking things. We learned that a couple of the people we had anticipated calling or relying on their testimony had a meeting with personnel on March 1st with the court, and that some of their information upon that meeting in Ada County on March 1st, it was different than the state had been originally given. It's a situation that evolves. Dealing with budget projections is sometimes reading like a crystal ball. And so that staff had originally given information to our witnesses, and they relied on it, and that resulted in our exhibits. And so in talking to those people and getting our witnesses ready, we learned that some of the information that we had originally relied on may now be different post the March 1st meeting. We asked the representatives to get us updated information or to talk to us about it, and they indicated that they were reluctant to do that without permission from the trial court administrator, for Your Honor. And so we called her, and she indicated that she was reluctant to give us the additional information without permission from you. I recognize, we all recognize that everyone is working really hard to do things by the book and to do things very fairly. And so the state is in a position where the information that we provided Mr. Pryor in anticipation of this hearing may be different. Maybe to the benefit of Fremont County, maybe not, we don't know, but the people we were relying on are reluctant to give us some of that information without permission from the court. And so we would be in this position if they change their mind or they give us updated information this afternoon, then we're turning things over late to Mr. Pryor, which is not fair, and we know that, which is why we filed for the continuance. We are simply working with our witnesses to get you as accurate an estimate as we can. We recognize the court and the trial administrator were doing their own due diligence and evaluating the situation. It's just our witnesses were unaware of that meeting, and they were unaware of how things had changed. And so we're in a difficult spot. I don't want our witnesses to get up there and say something that's inaccurate to the court, but we do not have the ability to get them accurate information because people feel they can't speak without permission from the trial court administrator, who indicated Mr. Wood that she wants permission from you to talk to us.
All right, Mr. Pryor, what's your response to the state's request to continue their hearing on their motion to reconsider set for tomorrow?
Judge, and I don't want to belabor the point. We had a motion to change venue, and that was back last year, in the late fall of last year. Prior to that hearing, the state intended to argue and wanted to argue that they wanted to provide additional evidence and sought permission of the court to provide that additional evidence. I filed a motion to continue that because I did not want to get information dropped upon me at the last minute. However, the court, in its discretion, denied my motion to continue and said, listen, the two of those hearings are linked together so extrinsically that we need to address this all at one time. Subsequent to that, the court issued an order changed the venue to Ada County, and denied the state's motion to allow the jury to be brought to Fremont County. The state then filed a motion to reconsider. But before the state filed the motion to reconsider, at that venue hearing, the status before the judge, you specifically said, Mr. Pryor, I'm not going to allow them to just dump information on you and not provide you an opportunity to respond. And I appreciated the court doing that. But what the court did not do is give Ms. Smith and Ms. Wood and Ms. Blake an opportunity to take a second crack at the apple. And now what we're dealing with is this, Judge, 3 or 4 months later, in excess of 4 months, we are now dealing with an opportunity where now they're calling more witnesses. But they had their opportunity to present the evidence, and they insisted on going forward on the day of the venue. They insisted, even though I said I don't want to go forward, they insisted on going forward. And now what they do is they drop this information on me, saying, here's our additional evidence. And they provided facts, they provided costs, they provided details, they provided information that they think supports their position for the court to reconsider its prior ruling. And the words reconsider, Judge, are very important because we've been down this road before. When Mr. Means was on the case with Ms. Vallow, Mr. Means filed a motion to reconsider, and this court ruled that there is no legal authority for the court to entertain a motion to reconsider. And if that was the court's position then, I would like it to be the court's position now and be consistent, that they don't get to go forward on a motion to reconsider. Not only that,
Mr. Pryor, I'll say there's a little difference here because in my ruling, I certainly left the door open. Part of the ruling was we were so far before trial because trial was scheduled so far out that even some of the information would maybe not be relevant or would be stale by the time we were actually getting to trial. And so unlike in that prior situation that you've mentioned with the other case, I think I did leave the door open here for the state to take a second opportunity for me to consider that. So I'd like to make that distinguishment.
okay. But Judge, that additional opportunity, and I would ask the court to go back and review what you said. My impression, and I may be wrong, is that the court said, I'll allow Mr. Pryor for you to provide information, allow the state to provide some additional information. Well, what is happening is the state has now disclosed 4 or 5 additional witnesses. They provided additional information. And if we rely on what Ms. Smith says, it's saying, Judge, when we first provided you the information several months ago, I don't know where the source of that came from, but they're now saying, Judge, we gave you some inaccurate information. And when we were providing our response or providing our authority to supplement the record from the previous hearing, we're now saying our information is not accurate and it's not correct. So Judge, after Mr. Pryor has filed his response and addressed all of their concerns and addressed why I think it should stay in Ada County, the prosecutor is saying now, after I have filed a response, Judge, a week later, well, maybe our information isn't quite as accurate because now that we look at this thing, we're getting some different information. Well, Judge, please forgive me if I'm a little skeptical about what this new information is going to be. And frankly, Judge, when they provide that new information, then what's going to happen is I'm going to look at it and change my tact potentially. And I'm going to need to get an expert witness. And I'm going to need to subpoena people. And this motion to decide what we do in terms of venue, where the jury is going to be sequestered, is going to drag on. Because if they provide me that additional information and it changes dramatically their numbers and to their benefit, they're going to cause me to have to do a full-blown analysis of what they're suggesting. Because I didn't trust their information the first time, and I surely don't trust their information the second time. And I think this is just another mechanism for these folks to try to continue this matter so that it puts a very difficult place for us to have a trial in January. And Judge, I would ask the court to deny their motion. And I would ask the court to not even allow them to present evidence because I view this as a motion to reconsider. And whether the court opened the door or not, I don't think they should get a second crack at the apple.
May I be heard, Judge?
Go ahead.
Briefly in response, we are not saying that the original information we gave was inaccurate. We are saying that given the way budgeting evolves given now that the parties know it's going to be in Ada County for jury selection at least, and potentially for the whole trial, that the information our witnesses relied on may have changed. In an abundance of caution, we are attempting to make sure that the information that we present at a hearing is given to Mr. Pryor ahead of time so he has a chance to look at it. We cannot do that because the witnesses feel they cannot discuss the changes or discuss the situation without permission from the court. Nobody's at fault. Everybody's just working really hard to follow the rules. And so we need permission from the court to let these people talk to us to see if the original estimates remain accurate or if things have changed, potentially to the benefit of Fremont County. And that is part of our due diligence in providing as close to an accurate estimate of economic impact as we can to the court. The second piece, and just so the state's position is clear, the court, and I've reviewed the entire YouTube proceeding on the change of venue, the court repeatedly actually granted Mr. Pryor's motion to continue matters. There's multiple sections where that's brought up. And the court, when respecting his need for notice, when the state asked a question that could verge on opening that door, the court limited those questions, but did tell the state that they would give us an opportunity to present economic evidence in the future should we feel the need to do so. So I just wanted to make sure the state's position is clear that the court was correct. And I agree with you, Judge, that you did not preclude us from bringing it up in the future.
All right. Well, this is a motion to continue, and I've considered the arguments and concerns raised by both the state and Mr. Pryor. I'll note the court has broad discretion in granting a motion to continue. I have to look at the overall administration of this case. As everyone knows, we're set for trial in January. Things are going to march along quickly between now and then. This is an important issue for the court to consider. As I have learned, it's going to take a lot of planning and effort and coordination amongst the counties in order to conduct the trial, where it's currently scheduled to take place in Ada County, which is what's been ordered at this point and has been approved by the Idaho Supreme Court. In terms of this motion, I'll note, first of all, this is the state's motion, and the state is now requesting the continuance and has raised a valid and legitimate reason in that they indicate that information that has been submitted in support of the motion may need to be corrected or updated. And so I do find there's a rational basis for bringing the motion, that it's not done simply for an unnecessary reason to delay. I understand the concerns raised by Mr. Pryor in terms of how that may require him to make additional preparation. And then in a moment, I'll get to the point of this argument that some permission from the court is needed in support of this motion. So given that the state raised this issue prior to the hearing, and in the interest of having true and accurate and correct information for me to make a determination, I am going to grant the state's motion to continue, their motion to reconsider. However, I want this continuance to be brief because I don't want this to impact any other aspect of the case in terms of it moving forward towards our trial date. So I'm going to have a few questions then for the state in terms of when you are going to have your additional information, when you can get that to Mr. Pryor. And then I don't want this to go out more than another 30 days, quite frankly, because the motion's been pending for a long time. We need to keep it on track. And then in terms of this permission from the court, I'll get back to that in a moment. But either Ms. Smith or Mr. Wood, what are your thoughts on when you will have your information so that it can be supplied in a timely manner to Mr. Pryor?
Your Honor, it's sort of intertwined with my next question, because I agree with you. I'm not sure that the court has to grant people permission to speak to us, but I recognize what they're saying. So if people will speak to us, we don't need more than 30 days. In fact, I suspect we need less.
Let me approach that point, because I don't go around and just give people permission to do something or not. In the case I either order something or I don't. And so
Right.
if you think somebody needs to be ordered, you need to submit a request for an order, and then an order would be issued if I find it appropriate. If not, permission's not something I grant or deny for people to speak about the case. That's governed by the rules. And
Right.
I have not had any request or no one's asked me to order anyone to talk about this issue. So I just want to be clear on that. Are you saying you're going to seek an order from me to compel someone to speak?
If their position remains that way, yes. And that's, I will be candid. I was surprised by that as well, Your Honor. So forgive me, we're a little, and so we will clarify with the individual, and it's the trial court administrator who works for your circuit. I think she wanted to make sure that she wasn't violating any rules. She's had a few days to think about it. So we will circle back with her to see if her position has changed. And if she feels that a court order is necessary, we will file that. We can know that certainly by Monday morning. I want to respect people's efforts to do everything by the book. I want to give them the opportunity to proceed. And if we need a court order, we'll do it by Monday.
All right. So when will you have your updated information available to provide to Mr. Pryor, if that's your thought on when you'll get that?
I certainly think we could provide it within the next 2 weeks. And I think I'm overstating that amount of time, but I don't want to get into a position where it's taking a while.
Okay. Well, and then that would give an additional 2 weeks. The issues out there, Mr. Pryor, the numbers are numbers. If you need to further review those, I think 2 weeks would be adequate time, knowing that the issue's been pending for a long time. So I'd like to look at setting a hearing then about 30 days out on the state's motion to reconsider. We'll vacate the hearing that's scheduled tomorrow morning. And let me look at my calendar for a moment.
Judge, before we do that, could I make a comment?
Go ahead, Mr. Pryor.
If they're intending to seek information and allow the trial court administrator to speak, I would like that order to include my ability to discuss it with the trial court administrator and have the opportunity. It seems that having it one-sided would be of a concern to me. So if they're going to ask this trial court administrator and submit an order, I'd like that order to include that I am permitted to contact the trial court administrator and discuss the same issues with her. Because quite frankly, Judge, if they give me information exactly 2 weeks from today, that gives me 2 weeks to find an expert, to find another trial court administrator or another person who can address those things. And then I'm in a position where I have to find an expert. I have to discuss it with an expert. And my whole concern about this thing goes back to this, Judge, is if the information is changed or hasn't changed, if nobody's talking, how do they know that? And this just seems like a delay to me, but I will obviously do what the court directs, but with the understanding that if you give me 2 weeks and I get the information in 2 weeks, Judge, I'm going to be in a very difficult position to provide a response. And I've already provided a lengthy response, and I'm going to have to go over it and do it again. And that seems to prejudice me a little bit, at least from my perspective, Your Honor. But I don't want to delay this either, Judge. I'd like them to have it to me within a week. And I don't see that there's any difficulty that they could not get this information to me within 7 days. It can't be that complicated.
All right, I'm considering that, Mr. Pryor, but I'm not giving any advisory opinion on any order that I haven't issued yet. So if an order is proposed, I'll consider that to see if it's an appropriate order given the circumstances.
Your Honor, just so the court's clear, the state wouldn't object to Mr. Pryor having access to that to anyone we would talk to.
Very
I mean,
well.
they're public officials.
Okay, I'm looking over my calendar, which has not got a whole lot of availability because trials have started again. Let me confirm this. I think I've got Wednesday, April 20th.
That works for me, Judge. Thank you.
The state, I can make that work, Your Honor. Let me check. I believe my colleagues can. Yes, that works for the state, Your Honor.
Okay, let's schedule that for 9:30 a.m. on Wednesday, April 20th. All right, that concludes then on the state's motion to continue their motion to reconsider. Is there anything else we need to bring up this morning at this hearing?
Judge, in regards to their motion to continue the motion to dismiss, I would like to clarify that it is one motion. Now, attached to part of that were two other motions that address some other issues as they relate to Ms. Smith and Mr. Wood. I'm not anticipating arguing those. I'm going to argue the motion to dismiss that was addressed in my brief and partially addressed in the other two briefs. And that's all I'm intending to discuss. Now, if the state needs more time on the 23rd, Judge, I will stipulate to giving them additional time. I did provide them 3 lengthy briefs, and if they need some additional time, I'm not opposed to them having that additional time. And we can vacate the 23rd if they would like a brief delay in hearing that one.
Your Honor, that if I can, we appreciate that. The motion to dismiss the primary motion, it is a lengthy motion. We would appreciate more time to respond to it. I'd note that in the when we had the scheduling conference on that, there was no time limit given on the state to respond, but we would like to provide that to Mr. Pryor in an adequate time as well. So we would like to continue that. We would like to get some type of scheduling in place for the other motions as well, Your Honor. As Mr. Pryor just said, they are interrelated, or that he would be arguing portions of them. And so we would like to get those on the calendar as well so we can respond and get those taken care of.
Judge,
Hold on, Mr. Pryor. I'd like an opportunity to respond. In this case, then we do have set a motion to dismiss on March 23rd at 9:30. The state's requested a continuance of that. And are you indicating, Mr. Pryor, that you don't object to continuing your motion to dismiss?
I don't object, Judge. I understand that the primary motion to dismiss was, my recollection was in excess of 50 pages long, and the two accompanying, although I'm not going to be arguing the accompanying motions that are different, 2 of the other briefs included facts that addressed the motion to dismiss as well. So given that, there's basically 3 briefs that address the motion to dismiss, and I did it in that way so that there was no confusion. As far as the other motions, the 3 other motions that I see, I would prefer that we allow the court to address the motion to dismiss. And at that point, once the court addresses that, if the court grants the motion, the other motions become moot. If the court denies the motion, then I can set a time to notice the other ones up. That would be my preference, Your Honor.
Well, with these lengthy motions, and again, going through my calendar, I do have that April 20th date open and could use that time. I do have this concern, though, that if there's a ruling or I need to take a matter under advisement on the motion to dismiss, I would prefer to have that argued and heard on the 23rd so that then there's time for the court to get a decision and possibly not have to go forward on the other pending motions. I guess I'd like to know why, again, on this motion to dismiss, that was actually, the motion was filed back in June of 2021. I mean, it was filed forever ago, and I understand that it took quite a time and an effort to compile all of the record that is necessary for review from the grand jury transcripts. And so I don't blame necessarily that delay on getting the hearing set, but now, again, continuing that out where I don't really see time in my calendar. I could probably get something before the 20th if I looked, but we're either setting everything together on the 20th or else we could still go forward on the motion to dismiss as scheduled on the 23rd. And I'd just like to know why parties couldn't be prepared to hear just the motion to dismiss on the 23rd, even if I were to allow for any additional follow-up briefing if required on the 23rd.
Judge,
Go ahead, Mr. Pryor. Why can't we do this on the 23rd?
Judge, and I will let Mr. Wood know, and Ms. Smith and Ms. Blake. I hope I'm not missing anybody. I don't intend lengthy argument on the 23rd. My concern is that some of the facts that I addressed in my memorandum are things that I'm not going to state in public. I'm going to probably submit on my brief and with very little argument, because I'm concerned about the privacy concerns of some of the citizens and some of the other issues. So at this point, I'm probably going to just submit on it or offer very brief argument. And I would be receptive to the state arguing and then supplementing my brief with a response within a period of time and allowing me a supplemental response and then allow the court to make its ruling. If that's the way the court wants to go, I don't think that would prejudice the state. They would still have the opportunity to submit a brief and get that to me within a time after the hearing on the 23rd. And I would be okay with that, Judge. And that way we keep this thing on track. If that's where the court envisions going, I fully accept that opportunity, Judge.
All right, Mr. Wood or Ms. Smith, I'd like a response to that in terms of holding the hearing on the 23rd, knowing that really on a motion like that, it's likely that it will require further review, and it's not a motion that court is likely to make a ruling on from the bench. Is there a reason why the state is not going to be or couldn't be prepared for argument on the 23rd with an opportunity to submit potentially a written responsive brief after argument?
Your Honor, if that's the method the court chooses, we'll certainly abide by that. We would like a little more time to adequately respond to the brief. I believe it's 55 pages long. There's a lot of points raised. There's a lot of case law to go through with it. And we obviously have already started on that, but we think the most effective method would be to have a little more time to prepare that brief. If the court does decide it wants to hear it on the 23rd, we will argue, but we would certainly want additional time to brief it after.
Okay, fair enough. Given the constraints we have at this point, I'm going to deny the motion to continue the hearing that was scheduled by the defense on their motion to dismiss for the 23rd, keeping in mind that there's likely to be a request for the parties to submit additional written argument or briefing post-argument at the hearing. But so we'll keep that on the court's calendar, and that's scheduled for 9:30 a.m. on the 23rd, and we'll hear argument at that time then. All right. Mr. Wood, is there anything else then on the case we need to bring up this morning?
Not from the state, Your Honor.
All right, thank you, Mr. Wood. Mr. Pryor, anything further for the defense?
Your Honor, I would just like the day as to when the state's to provide me the additional information. If I could have a specific day, I would appreciate it.
All right, I appreciate that. I neglected to mention that. So with the hearing we scheduled on the 20th for the state's motion to reconsider, let's schedule a time for disclosure of any additional information in support of that motion. We've got 4.5 weeks until that hearing. So would the state be able to have that to Mr. Pryor by the April 1st?
Yes, Your Honor.
All right, that'll give you about 19 days then, Mr. Pryor, to review that information for that motion. So the state will be required to file any supplemental information and provide any further information in support of their motion no later than 5:00 p.m. on Friday, April 1st. All right, counsel, thanks for your appearances this morning. Then that will conclude the hearing, and we will see you back on the record tomorrow morning.
Thank you, Your Honor.
Thank you, Judge.
Thank you.